incredibly honored that the great Justice Ruth Bader Ginsburg has agreed to join us tonight to talk.
The notorious.
The notorious RBG. When I saw you last, I asked you if before those T-shirts came out, you'd even heard of who the notorious B.I.G. rapper was. And what did you say?
I told Jeff that my law clerks informed me. I should just say, by the way, if you haven't been to the Constitution Center, you really must go there. It's fantastic what they have done.
Thank you so much for being such a good friend to us. On the little snippet of our recent interview that we used in this Khan Academy video, which, by the way, Elliot said he doesn't know how many of you have listened to it. We actually know exactly how many of you there are, and it's not very many. You've not done your homework according to Google Analytics. We violated your privacy in the course of discussing, realizing your reading habits, so listen up, because they're great. But I asked you what your favorite opinions involving civil liberties were during your years on the court, and you said VMI and the MLB cases. Tell us what those two initials stand for and why those two cases mean so much to you.
VMI, I think you know, is the Virginia Military Institute, a school supported by the state that excluded women. And the question was whether a state can maintain a facility offering tremendous benefits to one sex but not the other. There were so many people who had questions about the VMI case, and they went like this: well, why would a woman want to go to that school and expose herself to the rat line? So my response was, well, I wouldn't. My daughter wouldn't. You, although you're a man, you wouldn't either. But there are some women who are ready, willing, and able to undergo the rigors of VMI. Why shouldn't they have the opportunity? It was a very satisfying decision for me. As my husband put it, I won the Wertheimer case 20 years later. Now, what was the Wertheimer case? There were two schools for gifted children in Philadelphia. And one was called Central High, and the other was called Girls High. I thought the names told the story. There was a young woman who wanted to go to Central because it had better science and math facilities, infinitely better playing fields. But that opportunity wasn't available to her, so she brought a suit saying that she was being denied the equal protection of the laws. She won in the Court of First Instance, the Federal District Court. She lost 2-1 on appeal. The case came to the Supreme Court, and the Supreme Court divided 4-4. Now, when we do that, we are unable to render a judgment. We simply affirm the decision of the court below, and it has no precedential value for any other case. So the federal judges stood evenly divided in the Central High case. By the time we get to the Virginia Military Institute case, the decision was 7-1. And that, to me, was a sign of the change in that 20-year period.
And what changed? Our theme is the Constitution and change when it comes to civil liberty. Chief Justice Rehnquist, who dissented in some of the early gender cases you argued, changed his mind. Why did he change, and why did the court change?
Mm-hmm. Society had changed. If it didn't, we would not have had a chance to prevail. But women were doing all kinds of things. Doors were open to them in the 70s. There were There were very few occupations where women were not welcome. And as more women are out there doing things, it encourages young women to believe, well, this is what I want, and I can do it. So the court, a great legal scholar once said, it should never be affected by the weather of the day, but inevitably it will be affected by the climate of the era. I mean, one of the classic examples of that is Brown v. Board of Education. We had, not long ago, fought a war against racism, against the Nazis' persecution and torture and murder of Jews. And yet our own troops in the Second World War were segregated by race. Some people thought there's something terribly wrong about that. We are proclaiming that racism is odious, and yet we're practicing it ourselves. So I think that the time, the change, the people realizing how wrong it was to maintain racial barriers. It was the climate of that time that gave the impetus, I think, for Brown v. Board.
How can the justices know when social change represents the climate of the era rather than the weather of the day?
It's all around us. It's what our neighbors are doing, what our children are doing, what the press is reporting. It's inescapable. To go back to Brown, there was one concern that the United States government had. It was definitely part of the picture. At that time, we were in the Cold War with the Soviet Union, and the State Department, the government filed a brief in Brown v. Board urging the court to end what was basically apartheid in America, and said, we are being embarrassed constantly by the Soviet Union, charging that the United States is a racist society. Please, court, help us to end that era.
And yet sometimes the justices move too fast. You have famously argued that Roe v. Wade was too broad when it came down, that the social change was in the middle of unfolding, and if the court had ruled more narrowly, then reproductive rights would have been protected politically. This is a different version of the same question. What was the court's error in Roe, and how can it avoid that sort of errors in other cases?
The Texas law was the most extreme in the nation. A woman did not have access to an abortion unless it was necessary to save her life. It didn't matter that it would ruin her health. It didn't matter that the pregnancy was a result of a brutal rape or incest. So that case came to the Supreme Court, and the Supreme Court could simply have said, that's too extreme. That gives no credit at all to the woman's liberty. So it's unconstitutional, period. At the time of Roe v. Wade, this issue was it was all over the state legislatures. Sometimes the choice people won, sometimes they lost, but they were out there organizing and getting political experience. The Supreme Court's decision made every law in the country, even the most liberal, unconstitutional in one fell swoop. So the people who prevailed said, how great, we're done, we've got it all. The Supreme Court gave it to us. What happened? Opposition mounted, And instead of fighting in the trenches, state by state, to change the restrictive abortion laws, there was one clear target to aim at: the unelected justices of the Supreme Court. This is a decision that should be made, so the argument went, by the people's elected representatives, and not 9 at the time old men. The law was in a state of flux, and there were many states, including my home state of New York, that allowed a woman to obtain a safe abortion in the first trimester, no questions asked. There were 4 states that were in that position. There were other states that had grounds, like the woman's health, rape, incest. So the law was in a state of change, and I think it would have been healthier for that change to have gone on. Supreme Court would have struck down the most extreme law, then the states would react to that. The court usually doesn't take giant steps. It moves incrementally. And Roe v. Wade was a dramatic exception to that way of operating.
I think this is the theme of our conversation tonight, when the court should intervene and when it should pull back. This comes up in the death penalty cases, juvenile death penalty and the mentally challenged. Should you just count up the number of states that embrace a certain practice, and if more than half of them have done something, ratify that?
That's not what the court has been doing. On the death penalty, there was a time, how many years was it between Furman and Gregg?
73, and I'm not going to get it right away. So it wasn't a long time, it was a few years.
The Supreme Court had struck down the death penalty because they said it wasn't being administered with an even hand. No account was taken of mitigating circumstances. And there were no standards for who would live and who would die. I think, and so for many years there were no executions in the country. Then states began to change their laws to set standards. It's not your everyday murderer that gets the death penalty. It has to be a heinous, cruel, atrocious murder. The worst of the worst fit that category. So then the state said, we have standards, so let us now say for ourselves whether we want the death penalty. And the Supreme Court looked at the standards and they said, okay, you can have it. I think if the Supreme Court had not decided the way it did, we would have no death penalty in this country and it wouldn't even be controversial.
So this danger of backlash is
Yes.
the theme. There's a real danger of backlash. On the other hand, you don't want to be inflexible in the face of changing technologies. I found inspiring the 9-0 Riley decision, the cell phone decision from last year, where all 9 of you agreed that for the cops to search a cell phone when they arrest someone and look at all the information on there was like the general warrants that sparked the American Revolution, because our lives are on our cell phones.
Yeah.
How were you? You're not. Well, you don't. I don't think you're especially tech savvy. I've known you a long time. What sort of apps are?
Bennett, do you have my purse?
Let's see.
Oh,
Let's see.
well,
Can you show us your apps?
During the argument, people said, well, Supreme Court justices don't carry 2 cell phones.
Let's see.
And so we're going to dig them out.
Do you have an iPhone 6?
Oh,
yet?
well, I left them in chambers. What a shame. Anyway, I do.
You have 2.
Yes.
A private one and a public one, which is very sensible, and we should all follow that privacy
one
practice.
that I can work easily and the other I can't.
But this was, the rule had been that anything, if you're arrested, anything in your pocket is fair game. So if you have a wallet, or if you have a diary, and the police have probable cause to arrest you, they can take anything that's on your person. And so the government urged, a cell phone is carried in one's pocket. It's just like a wallet, it's just like a diary. Well, the Supreme Court was savvy enough to know that you can pack into that cell phone much more than in the founders' days an office with file cabinets could contain. And so the court said, no, if you would like to search a cell phone, the police would like to search a cell phone, they have to do what is the main rule for search and seizures: get a warrant, go to an impartial magistrate and show good reasons for your need to inspect this cell phone. And we never got to MLB, but we'll get back to that.
We will, because these tech cases are so fascinating and so important because, as you say, people live their lives on their cell phones, as you know as well. There was the case involving GPS tracking, the Global Positioning System case, where the court held, again, 9-0, although there were important differences in reasoning, that the cops can't put a GPS device on the bottom of a suspect's car and track his movements 24/7 for a month. And some people thought the argument was lost when the Chief Justice asked the first question. He said, is it the government's position that you could put a GPS device on the members of this court and track our movements? And the lawyer said yes, and the case was over. How much does it matter that you can envision your own privacy being invaded in these cases?
Maybe we can get to MLB in that respect, because it was a case where I think my colleagues initially didn't have the understanding that they should have had to decide this case. MLB was a woman who was in a proceeding to terminate her parental status. The social workers had said she was an unfit mother and therefore her child would be taken from her. She would be declared a non-parent. When she lost the case in the court of first instance, she wanted to appeal. But in order to appeal in that state, you had to have a transcript. MLB had a volunteer lawyer, but she didn't have the $200 that it took to buy a transcript. And so the Supreme Court of the state said, sorry, we can't entertain your appeal. You haven't paid the fee for the transcript. And that case went to the Supreme Court. And her argument is, I am being deprived of the most precious thing to me, the right to be a parent to my child. The argument against her was, you are in a civil proceeding. In criminal cases, if you are poor, the state will provide a lawyer and they will provide whatever fees are necessary. But your case is civil. So it was the distinction between civil cases, you're on your own. Criminal cases, you get a lawyer and expenses paid by the state. I think most women appreciate that the loss of one's child is more devastating than 6 months in jail, much more devastating. So once the decision makers had that understanding, they were prepared to modify this rigid line between civil cases and criminal cases. And the court decided in MLB's favor that she had been denied due process by having her appeal rejected simply because she didn't have the money to pay for a transcript.
So you've identified two of your favorite cases, VMI and MLB, in which you persuaded your male colleagues to empathize with women who had suffered discrimination and injustice.
And yet, there's another good case in that category.
Yes.
It was the strip search of a 13-year-old
Yes.
girl who was suspected of taking drugs to school, pills. The pills turned out to be Advil. In any case, she was taken to the girls' room and strip searched. Her mother was incensed that her daughter was subject to such humiliation. So she sued the school district for damages and also for an order that you must never do this again. To some of my colleagues, well, there was even a remark from the bench. The boys and 13-year-old boys, they go to the locker room, they're not wearing any clothes. It's not a big deal. I suggested from the bench that it is a big deal for a 13-year-old girl. She's in a very vulnerable stage of her development. Well, that case came out the right way.
That was nearly unanimous as well. But some of your greatest dissents, and I have to say I love your dissents as much as the majority opinion, because you're on fire in these dissents. There was one of them a few years ago, Smith and Doe, you may not remember it, it was the Alaskan sex crimes registration database. And the court upheld this, and you pointed out in dissent that all the bad information about you is up online, but you don't get a chance to put up the good information and put yourself in context. You weren't obviously empathizing with the suspect in that case, but what's your thought in a civil liberties case where you really have to side with the unpopular side in order to defend constitutional values?
Most of the great constitutional decisions were made in cases brought by people that you and I might not like to have as our best buddy or next door neighbor. If you think of Gideon against Wainwright. But if we don't protect the people we don't like, we're going to lose protections for ourselves. I mean, the Fourth Amendment doesn't say you can search the bad guys, but not the good guys.
Speaking of recent civil liberties dissents, your recent Hobby Lobby dissent was something that you obviously felt very strongly about. Tell us about why you felt so strongly about that case, and also that remarkable follow-up in which you accused your male colleagues of having a blind spot when it came to women's issues.
Yeah. The Health Care Act has a list of medical services that must be provided to insured employees. And on that list was contraceptive services, essential preventive care for the woman. Hobby Lobby's owners had a deeply held, totally genuine belief that using certain contraceptives was sinful. And so they said, we won't provide that coverage. Now, if Hobby Lobby had been a religious organization, if it had been a nonprofit serving a religious community, well, the question never would have come up because the members would all be part of the same religious community. And so the members would not even ask for access to contraception. But Hobby Lobby was in business for profit. It employed hundreds of women who did not share those religious beliefs. And as a great scholar once said, I have freedom to swing my arm until it hits the other fellow's nose, and then I have to stop. So my point was, if you're going to employ people, a diverse workforce, you cannot foist your beliefs on the people who work for you. That's the choice you want to make. If you want to be in business, then you have to play by the rules that all other businesses play by. And you can't disadvantage the people who work for you based on your belief, which they do not share. That was essentially my position in the Hobby Lobby case.
And when you talked about a blind spot, are you concerned that the decision might be expanded to lead groups to claim exemptions from generally applicable discrimination laws?
Well, we will see. I mean, I said, what was the word? I said something like, the court is entering a minefield.
Yes.
And I gave a couple of examples in the dissent. And one of the examples was a religious sect that had a deeply held belief that a woman must not work unless she has the permission of her father or her husband. Now, could an employer who is of that view say, I know about Title VII, this anti-discrimination in employment law, but this is my religion, so I have to get an exemption from that law. That was one example. And there are many others. I mean, one case that I had in the years I was on the D.C. Circuit, Jeff, I don't know whether, I think it was before your year, but in any case. This was a case brought by the Ethiopian Zion Coptic Church that had a sacrament. Their sacrament was marijuana. Now, unlike the Native American church and peyote, which is smoked only in the religious ceremony, very carefully guarded to see that no one leaves intoxicated. This sect, their sacrament was marijuana ingested all day, every day. So they wanted an accommodation to their deeply held religious belief.
Do they live in Aspen by any chance?
So it's going to be interesting to see what will come to us as a result of the Hobby Lobby decision.
And the McCullen abortion clinic bubble case seemed to be unanimous, but you noted that some of these cases that look unanimous actually have deep divisions underlying them. Tell us about McCullen.
This was Massachusetts' attempt to deal with demonstrators at abortion clinics. The legislature passed a law that said we want a 35-foot buffer zone surrounding this clinic, and nobody can cross that line. The case was brought by women who called themselves counselors, and what they said is, we are not rock throwers, we're not shouters. We want to have a conversation with the women before they enter the clinic and tell them there's an alternative. But we can't get near them because of this 35-foot buffer. The court made one key ruling, and it was that the state can restrict speech when that speech endangers other people. So for the boisterous demonstrators, the state of Massachusetts, because they were out there, could take measures to protect the people who wanted access to the clinics. But Massachusetts had gone too far because the record showed that some of the clinics never saw a demonstrator. The demonstrators came mostly to the clinic in Boston, and they came mostly on Saturdays. So the court decided, yes, you can have restrictions to protect people's access, but you can't go so far that you are inhibiting people like the plaintiffs in that case. So the instruction was Massachusetts, rethink your law, come up with something that is less restrictive than this 35-foot buffer zone every day and in every place. There was a strong disagreement on the court about the first step, that is, could you have these laws aimed at people who were trying to impede access to the clinics? The court said, yes, you could. And then the court was divided on that question, which will be very important because when a legislature passes a law to protect entrance into a clinic, as long as they do it reasonably, as long as they don't go overboard, it will be okay. That's the principal method of that case, message of that case.
What I find so inspiring about your remarkable legacy is it combines a passionate willingness to defend civil liberties when necessary with a sensitivity and incrementalism to the opinions of society as a whole, and a belief at heart that it's up to the people, social change, women and men, to actually advocate civil liberties on their own.
Yes, well, it worked wonderfully well in the 70s. You know, people give me credit for the elimination of gender-based barriers. I was just lucky to be alive and a lawyer when it became possible to get the court to change its views on that issue. The women's movement had come alive. Women were agitating for their rights. And the cases that came to the court were easy in the sense that the court wasn't asked to change the world or to take Sally Reed's case, the first case. A woman whose son had died under tragic circumstances. He was a suicide. She and her husband were divorced. She was given custody of the child when he was of tender years. When the boy reached his teens, his father said, now it's time for him to be prepared for a man's world, so I should be the custodian. And the family court judge decided for the father, much to the distress of the mother. When the boy died, she wanted to be appointed administrator of his estate, not because there was any economic gain involved. He had a record collection, a guitar, some clothes, a small bank account, and that was about it. Her ex-husband, perhaps out of spite, applied. And these rival applications came before the probate court judge, who said, Sally Reed, I'm terribly sorry, but the law decides this question. It reads, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Well, the Supreme Court could see that that was wrong. It could see it because it was all around them, that women were no longer settling for a tiny corner in a man's world. And so they decided, read unanimously, and every case in the 70s was a step forward. Some of them involved men. And my favorite was Stephen Weisenfeld's case, Stephen's wife died in childbirth. He was left as the sole surviving parent, and he vowed that he wouldn't work full-time until his child was in school full-time. He applied for Social Security benefits that he thought were child-in-care benefits. And the Social Security office person told him, this is the law. You see the heading? They're called mother's benefits. So these benefits are available to a widow, but not a widower. He brought that case to the Supreme Court, and it was a wonderful learning device, I think, because the court got it. They agreed unanimously on the judgment, divided 3 ways on the reasons. Most of them said it's obvious where this discrimination begins. We have a Social Security system. Everybody pays Social Security taxes. Man or woman, you pay the same taxes. But the woman's taxes do not net for her family the same benefits as the man. So the discrimination is basically against the woman. A couple of them thought, this is really discriminating against the man as parent. It says, we don't expect you to have, when you're the sole surviving parent, to take care of your child personally. You work and you pay somebody to take care of your child. And my later chief, then Justice Rehnquist, said, this is totally arbitrary from the point of view of the baby. Why should there be a chance for the child to get the personal care of a parent if the parent is female, but not if the parent is male? So those cases, I think, were successful. The court didn't think it was overturning, making any revolutionary change, but in fact it was revolutionary, because up until the year 1971, the Supreme Court never found a gender classification that it didn't approve. We go way back to when the 14th Amendment, which introduces the Equal Protection Clause into the Constitution. In the early 1870s, a woman named Virginia Minor said, how grand, how we have, I'm a person entitled to the equal protection of the laws. The most fundamental right of a citizen is to vote for the people who will represent her. So I am a person, I am a citizen. It follows that I have the right to vote. Supreme Court's answer in that case was, of course you are a person, we don't doubt that for a moment, and you are a citizen. But so too are children. And who would think that children should have the right to vote? It was women and children go together, birds of a feather. The notion was that all of the differentials in the law were benign, that they were protective of the woman. So to take one of the cases, Gossett against Cleary, so a woman owned a tavern, and her daughter was her bartender. Michigan passed a law that said a woman can't tend bar unless her father or her husband owned the establishment. Immediately, these two women were put out of business. But the Supreme Court's reaction was, this is a protective law. Oh, we've heard these rumors that it was really the Michigan Bartenders Union that pressed for this. But bars are dangerous places, and we have to protect the women from the drunkards that frequent those places. One of the many ironies was that the law said the woman couldn't serve bar. She couldn't be behind the bar. But there was no restriction on women as waitresses bringing drinks to the drunkards at the table. Anyway, but the Supreme Court said that this law protects women. Or, in not so long ago days, many states didn't call women for jury duty. Why? Because they were the center of home and family life. The case came to the court in 1961 when the court was supposed to be, quote, liberal, when Earl Warren was the Chief Justice. The case was Gwendolyn Hoyt. She was a woman, we would now call her a battered woman. She had an abusive, philandering husband. They got into an argument. He humiliated her to the breaking point. She saw her son's baseball bat in the corner of the room, and with all her might, she hit her husband over the head with it. He fell against the stone floor. That was the end of their fight and the beginning of the murder prosecution. Gwendolyn Hoyt found that she would have no women on her jury. And she thought that that denied her due process and equal protection. So her case went to the Supreme Court, and the Supreme Court's attitude was, we don't understand this complaint. Women have the best of all possible worlds. True, they're not on the jury roster, but if they go to the clerk's office, the court clerk's office, they can sign up and put their name on the roll. So this differential treatment of women was meant to be protective of women, to be respectful of their duties at home and taking care of children. What that said to the people who thought about it was, she has just been, all women have just been declared less than full citizens, because citizens have obligations as well as rights. And one of those obligations is to participate in the administration of justice. A law that doesn't put women on the jury rolls is saying men are obliged to serve. We need them. But women are expendable. We don't need them. And that does not treat a woman as a full citizen. And the court realized that in the 70s. It didn't in the 60s.
I know the audience has questions, and I want to take some of them, but I want to ask you one more right now, which is, what is your advice to young women who want to make a difference today? We had on Monday the extraordinary experience at the Constitution Center. We gave the Liberty Medal to Malala Yousafzai, who's just won the Nobel Peace Prize. And this is the most inspiring 17-year-old girl you can imagine. She wrote on her blog, she criticized the Taliban for denying access to education to young women. She survived an assassination attempt, and she has just inspired the world with her advocacy of the importance of education and free speech. Is that the model to follow? Would you encourage young women to be lawyers, to be activists, to be Supreme Court justices? How can they make a difference?
By not taking no for an answer. If you have a dream, something you want to pursue, and you're willing to do the work that's necessary to make the dream come true, don't let anyone tell you you can't do it. And you have nowadays many like-minded people who can join with you in opposing unfair treatment of you as less than a full citizen.
That's, I think, precisely the advice that Malala's father gave her, and that confidence that with education and hard work you can do anything is something that's so crucial to success. Ladies and gentlemen, you've submitted some questions on by email, and I have them here, but I think I'm going to ask one from the list that came in, and then I'll invite you to raise some more. And this is the question. Justice Ginsburg, the audience asked, do foreigners abroad or in the United States have the same right to privacy as U.S. citizens, and why? Or why not?
Well, I can give you two answers. One is anyone who is within our borders. Anyone has the right to due process and equal protection because the Constitution speaks of persons. So let's find the 14th Amendment. It says, nor shall the state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction. The use of the word person means that any person is entitled to due process and the equal protection of the law. It's my firm conviction that the Constitution follows the flag. That is, wherever a U.S. representative acts, our Constitution is her guidebook. That view is not shared by the current majority, but I think someday it will. There was a good illustration of that, a most unusual case back in the days when Germany was divided. Two people from East Germany hijacked a plane and brought it to Berlin, in the West Berlin. And skyjacking is a crime, but it was embarrassing for the Germans because the view was there is one Germany, not East or West. So if you live in the East, you should have free access to the West. So the German authorities didn't know what to do with this case. The United States offered a helping hand. They said, left over from World War II is this U.S. court for Berlin. So we'll revive it, and we'll send a U.S. district judge to preside over this trial. It will be tried under the German criminal code, but by a U.S. judge. The U.S. judge arrives, and the first thing he asks, where are these people? Do they have lawyers? They didn't, but he made sure that they had excellent counsel. And then he said, well, now we need a jury pool. Jury pool. Germans don't use juries. And the judge said, I do. Wherever I am, wherever I exercise my power by virtue of the Constitution, the rights guaranteed in the Constitution must be respected. I mean, the State Department was no end disturbed at this notion, but it was quite remarkable. They played by all the rules. The defendants got all the protections that they would have had if they were tried in a U.S. court, but they were tried in a court in Germany, and the governing law, the governing substantive law, was the German criminal code. So that was a man who believed, as I do, that if you are a federal official, this Constitution is your guide, whether you're acting at home or abroad.
Magnificent example. And as you say, the majority of the court has held otherwise, but individual judges can insist on having the Constitution follow the flag. Ladies and gentlemen, your questions for Justice Ginsburg. I'm a law professor, so I can call on people, of course. Yes.
Thank you so much. I was interested to hear you talk about the demonstrations outside of the abortion clinic, and I'm curious to hear about the Westboro Baptist Church and how you see that case as similar or different. Thank you.
The Westboro Baptist Church, these were people who was against the United States participation in which war was it? It was Iraq. Yeah, Iraq. So they decided that one way they showed their opposition to our intervention in Iraq was to have demonstrations at funerals of people who had been killed in service in Iraq. A really horrible thing to do. They were restricted to an area. They were not allowed to come anywhere near the church, but where they could be seen by people who were taking that road to the church. The court's decision was these people would have no right to disrupt the service. They have no right to block entrance into the church, but they do have a right of free speech. And as much as we may find their speech hateful, as long as they're not harming anyone, they have a right to speak. The government can't censor the speech that we don't like. You know, this is an issue that has been burning since the nation was new, and there was at the time when the nation was just formed. It was a cartoon showing an American soldier carting off a British Tory to prison. And the caption was, "Liberty of speech to those who speak the speech of liberty." Government can't tell us what's the right way to think, to speak, to write. And as long as we're not endangering others, that right must be respected. And we can't have a big brother telling us what's the right way to think and to speak and to write. So that was, I thought, a very important case. Every one of us thought that it was a most dreadful thing to do. But there have been a lot of people, dreadful speakers in the history of the United States. And because they were allowed to speak, all of us can feel more secure in our right to speak. There was, do you know the song Ballad for America? No. It's, I think Paul Robeson sang it, but anyway, it's the right to speak my mind out. That's America to me.
Oh, that's great. That's really beautiful. Yeah, yes, sir. No, go ahead.
Okay. Justice Ginsburg, thank you so much. I wanted to ask you about the right of privacy. I think if you were to ask most citizens, I think most citizens place a high premium on their privacy and want to see it protected. And the Constitution protects against unreasonable searches and seizures. But in an era of ever more pervasive technology and intrusive technology, where people can gather so much information about you without ever contacting you physically or even engaging you personally, is the right of privacy just kind of a relic of the past? Is it is it kind of naive for us to think that we really have a right of privacy? And how should the courts, how should the Constitution adjust to an era of social media and technology that really make privacy seem like a flimsy notion? Thanks.
There is no right of privacy written into the Constitution. There is the Fourth Amendment protecting people against unreasonable searches and seizures. But there is a notion, an important notion, of liberty, that we should have liberty to carry on with our lives without Big Brother looking over our shoulder. That idea has come from the guarantee, the due process guarantee of liberty, rather than an explicit right of privacy. I am going to pass this question on to someone who is a great expert, has written books and articles about the right of privacy, and that is Jeff Rosen.
You were very kind and much too generous, and I'm not going to intrude on a moment of the audience's time with you by giving you my thoughts, but we are going to talk about it more on the AspenX videos in our great Senate Socrates seminar tomorrow. So thanks for asking that great question. You're being much too modest. You've written so much about this technological change, and you are a hero of privacy, and I think your opinions show, like Louis Brandeis's, that you identify the core values that the framers were trying to protect, protection against general warrants and so forth, and translate that in light of new technologies. And that's what you stood up for very well indeed. Rich.
Thank you. Justice Ginsburg, first of all, it's an honor to be here and to attend and hear you, and even more of an honor to have the opportunity to ask you a question. My question has to do with your dissent in Hobby Lobby, if we might return to that for a moment. For much of the opinion, you go through an analysis showing how, in your view, the request for the accommodation was not required under the standards of RFRA, a powerful and appropriate statutory analysis. But at the very end, you seem to be suggesting, casting doubt on the very enterprise of providing for accommodation for religious practices by having a statutory provision that says, at least under that standard, that an accommodation needs to be provided not to put people in a position of violating their religious beliefs unless there's a compelling interest that can't be met by more narrowly tailored means. And you seem, if I read it right, to be suggesting that's a questionable enterprise. Am I reading too much into the conclusion of your dissent? And if I'm correct, okay,
yes,
good.
you are.
Okay, good. Because I would like to hear from you how then, if I might just finish, we are to deal with minority faiths who find themselves in conflict with general rules of applicability.
The accommodation to religious practices has come up, say, for Sabbath observers. If the employer is able to accommodate without disrupting the rest of the workforce, the employer must. By accommodating to this religious belief, and therefore depriving the workforce of the insurance that the government said they should have. It's the point that I made before, yes, accommodation, but not when your arm is hitting at the other fellow's nose. Yes, all kinds of reasonable accommodations can be made. We're going to have a case a little later this term of a woman who worked for, was either FedEx, it was a courier service. She was a driver, and she delivered packages. Her doctor told her that during her pregnancy, she should not lift weights over 20 pounds. Her co-workers were ready, willing, and able to help her and do the heavy lifting that she couldn't do, but the employer said, no, I don't have to accommodate to you. you're not disabled. I have to accommodate to disabled people, but being pregnant is not a disability. So she was discharged, and she was hired back. And when she was hired back after childbirth, she said, "Well, no, I want to get compensation for the time I was wrongfully discharged. You had an obligation to accommodate to me." And that's one of the cases that we will hear this term. It comes up because, in the 70s, the Supreme Court decided a case about pregnancy and ruled that a woman can't complain about pregnancy as sex discrimination because discrimination on the basis of pregnancy is not discrimination on the basis of sex. That was a stunning thing for the court to do. And Congress very quickly passed the Pregnancy Discrimination Act, the soul of simplicity. The law said, discrimination on the basis of pregnancy is discrimination on the basis of sex. So that is the law that the woman in this case is invoking against the employer who discharged her because he wouldn't accommodate to her weightlifting restrictions during her pregnancy.
Justice Ginsburg, you know that I would love these conversations to go on all night, but the one requirement of National Constitution Center and Aspen Institute panels is that they end on time. So I have to tell you, well, first of all, I want to give you, as a gift, the latest version of the National Constitution Center Pocket Constitution. It has a new introduction, and please carry
Thank
this
you
one
so
as
much.
well as your well-worn official government one. But I just had the incredible privilege of having a bunch of conversations with you recently, and after each one of them, I feel so inspired and so lucky, and I know that I really want, there are a bunch of t-shirts going around, I want the one that says WWRD. When I have a hard privacy and constitutional question, I ask, what would Ruth do? Ladies and gentlemen, please join me in thanking the notorious, glorious RBG.